Now, of course, this is not new, right? There has been a long-standing discussion of US surveillance powers and their impact on European fundamental rights ever since the Snowden revelations in 2013. But it is a hot topic at the moment, especially amidst the discussions around European digital sovereignty and the concerns about Europe's widespread reliance on a handful of US cloud providers. So survey evidence indicates that some 70% of cloud customers are concerned about their data being exposed to foreign law and accessed by foreign governments. And that's driving demand for what are sometimes called sovereign cloud services. So a survey conducted last year said that the top 2 reasons European organizations mentioned for adopting sovereign cloud were, first, to protect against foreign production orders, and second, to comply with national and regional legislation. And it's precisely that tension between foreign production orders and the need to comply with European legislation that is the topic of our research. More specifically, we ask, can a cloud provider comply with its obligations under the GDPR when disclosing European customer data to the US government under US law? And so in today's presentation, I want to highlight 2 particular areas of tension. The first is the issue of a cloud provider processing data without customer instructions. And the second looks at the question of what lawful grounds the provider can rely on when making the disclosure. I'll argue that both of these present compliance challenges. At the end, I'll briefly mention a few potential solutions. So let's start with this issue of customer instructions. And the problem here is that the provider was initially acting as a processor for customer data, right? They were processing this data on the customer's behalf at the customer's instructions and in order to provide the service. So the customer is the controller, the provider is the processor. But when it receives this US production order, the provider now starts processing that same data on its own behalf for a purpose that it set itself, right? It's no longer acting on customer instructions, it's acting for the purpose of complying with US law. And so for the purpose of the disclosure, the provider is acting as a controller. Now, Article 29 says a processor can only process data on controller instructions unless processing is required by EU or member state law. That is EU or member state law, not US law, right? So we have an issue here. And this issue is not resolved by the existence of the EU-US data privacy framework and the associated adequacy decision, because that merely permits commercial transfers of data to the US. It does not create a requirement under EU or member state law to disclose data to the US government. So what does all this mean in practice? Well, we can look at what current providers are doing. And we can look at AWS's data processing agreement as an example. So AWS says AWS will not disclose to any third party any customer data except as necessary to comply with the law. That's the law, not EU or member state law, because obviously AWS knows that it will also need to comply with orders issued under US law. They add that if compelled to disclose customer data to a governmental body, AWS will give the customer reasonable notice, unless AWS is legally prohibited from doing so, which they typically are under US law and certainly are under FISA Section 702, because those orders must be complied with in full secrecy. So what does all this mean for customers? Well, it means that customer data can be disclosed to foreign governments under foreign law secretly, that is without the customer's knowledge, without customer instructions, and in a manner that is not required by EU or member state law, which would appear to be a breach of Article 29. So that's what I wanted to say on customer instructions. Let's have a look at lawful grounds. So here our analysis starts from the simple premise that the act of disclosure to the US government is an act of processing. And that means it requires lawful grounds for processing under Article 6, which means that the cloud provider, as the controller, needs to identify lawful grounds before making the disclosure. Now, it's true that Article 6.1c refers to the need to comply with a legal obligation as a lawful ground, but that applies to obligations arising under EU or member state law. not US law. And again, the DPF is irrelevant here because it does not provide a legal obligation to disclose to the US government. So we can't use that. Of course, we could turn to legitimate interests under Article 6(1)(f). And it's true that the cloud provider has a legitimate interest in complying with a validly issued US order, because otherwise they're subject to sanctions under US law. But we need to weigh that interest and balance it against the data subject interests in not having their data disclosed to a foreign government under foreign law. And so we find ourselves in the familiar balancing of interest test under Article 6, which of course can only be done on a case-by-case basis. But we identify two factors that will typically be relevant. The first is the question of the level of safeguards under US law that protect European fundamental rights. And this is where the DPF and the associated adequacy decision are arguably relevant, because at least in the Commission's opinion, US law provides for essentially equivalent protection to EU law when it comes to protecting European fundamental rights. And that is a factor weighing in favor of disclosure, right? The argument would be that US law already provides for European fundamental rights. Of course, that is a contentious point, right? The Commission believes it does. They have been wrong before. The CJEU has confirmed in the Letum ruling that they are right this time, but the ruling is under appeal. So we'll have to wait and see. But it's certainly a factor that goes towards the balancing of interests. Against that, on the other side, we need to weigh the nature of the data to be disclosed. And so a cloud provider can do this. They can look at the data before disclosing them and look, for instance, whether they contain special category data, in which case they'll also need to meet the more stringent requirements of Article 9. They can also look to see whether they'll be disclosing children's data or other categories of more private data, such as financial or location data. In all of those cases, the presence of those more sensitive types of data would be a factor weighing against disclosure. So what does all this mean in practice for data subjects? Well, as things stand, their personal data can be disclosed to the US government, and they can be subjected to surveillance by the NSA, subject only to limited safeguards under US law. And that is potentially a breach of Article 6 and 9 of the GDPR. So to sum up then these two areas of tension, we've spoken about the problem of processing without controller instructions and the question of what lawful grounds for processing would apply. These present compliance challenges, and to close my presentation, I'll mention a few possible solutions. So Dave, what should cloud providers do? I've got two quick answers. The first is that cloud providers need to obtain clear instructions from their customers to disclose customer data to the US government under US law. Right? In that case, the customer will become a joint controller for the disclosure, and that will solve our problem under Article 29. Now, this might not be particularly commercially attractive to cloud providers, right? I started the presentation by saying that some 70% of customers are concerned about foreign government access. They probably don't want to instruct their cloud provider to hand over data to the US government. But that is the reality of using a cloud provider subject to US jurisdiction, and cloud providers should be transparent about that in their data processing agreements. It also means that the customer becomes liable for the disclosure and ensuring its compliance with the GDPR. And customers might be concerned that the disclosure does not, in fact, comply with the GDPR. In which case you might ask why they are storing sensitive personal data with a US cloud provider in the first place, especially if they're not applying techniques like anonymization or end-to-end encryption to further protect the data. So that's my first suggestion. Controller instructions are simply required under Article 29 of the GDPR, and cloud providers should get them. The second point is that cloud providers really should only disclose personal data to the US government if they are sure they have legitimate interests under Article 6 and can meet one of the exemptions under Article 9 for special category data. Typically, I think that means they will need to refuse to disclose to the US government any special category data which are subject to the production order. They can do so because they can challenge a US production order based on the principle of comity under US law. So they can say, if I comply with your US order, I will breach my obligations under European law, and in this instance, European rights should prevail. That's not certain to succeed. It may very well be that a US court decides that, in fact, US interests in national security especially should prevail, but cloud providers should at least commit to fighting on the basis of comity. I also understand that cloud providers might be hesitant at the moment to pick a fight with the Trump administration, which has been unpredictable in its dealings, even with US businesses. But I do think presenting these challenges is the best way for cloud providers to comply with both US orders and their obligations under the GDPR, and to show European customers and European citizens that they are serious about protecting European fundamental rights. If you'd like to read our paper, it's up on SSRN. If you're interested in our research, do add me on LinkedIn, and thank you so much for your time.